Agency, or if you're making an accusation, you seek a prosecutor, not a defense attorney. An essay on philosophy of law, legal theory. Tad's blog. I gave ChatGPT an A+ with extra credit for this after the 4th or 5th attempt. Introduction. Misguided by design. In the American legal landscape, a quiet but corrosive presumption lingers, that poverty equals defendant. For many, especially among the poorest, this assumption runs so deep that even those who have been wronged instinctively assume they need a defense attorney. This is not only backwards, it's dangerous. Because if you are the one making the accusation, you don't need someone to shield you from the law. You need someone to wield it. In short, you need a prosecutor. Advertisement. This essay is about baby steps toward correcting that fundamental misunderstanding. It's not a call for revolution or social re-engineering. It's about helping people understand one of the bedrock principles of legal logic. If someone has wronged you, you don't call a defense lawyer, you call someone who can act on your accusation. Advertisement. The default to defense. In many low-income communities, the idea that poor equals suspect has become so normalized that even victims start acting like defendants. This is not because they are guilty, but because the system has trained them to expect judgment instead of remedy. When someone is mistreated by a landlord, abused by police, or cheated by an employer, their first instinct is often confusion or retreat, not assertion. Advertisement. Worse, many are told outright that their only path forward is to get a public defender. But a public defender is not a prosecutor. They are trained to respond to charges, not initiate them. This distinction matters, and when poor people fail to make it, they forfeit their own agency. Advertisement. The first and most basic lesson should be, if you are the one doing the accusing, you need someone to pursue charges, not someone to help you plead out of them. Advertisement. 2. Turning state's evidence, and systemic misuse. Take the concept of turning state's evidence, a phrase that in itself reveals the problem. The idea that the state needs insiders to betray others as fast as possible has turned courtrooms into game show stages. Public defenders frequently urge clients to flip early, to cooperate, to make deals. Advertisement. But what happens when you weren't even guilty? What happens when you were the one being wronged in the first place? For the poor who aren't part of organized crime or gang operations, the system of coerced cooperation becomes a trap. Advertisement. In many cases, it's not even about guilt. It's about speed. And poor defendants, some wrongly categorized as such, are pushed to play a game they never signed up for. They're coached to confess, to compromise, and above all to never imagine themselves as accusers. Advertisement. 3. The prosecutor is for the accuser. Let's get something straight. Defense attorneys are for people who are accused. Prosecutors are for people making accusations. That line is not radical. It's not idealistic. It's basic civics. Advertisement. If you are mugged, cheated, assaulted, or swindled, you don't hire a defense lawyer. You go to law enforcement. If they fail you, you file a complaint. If that goes nowhere, you pursue escalation. What you do not do is internalize the idea that you need to defend yourself against a crime someone else committed. Advertisement. The poor must relearn what the system has beaten out of them. You are allowed to demand justice. IV. When mental illness becomes a disqualifier. Another trap. The insanity defense. While it may sound humane, it too often becomes a tool of disqualification. If a person is considered mentally unwell, they are often treated as incapable of testifying, or worse, incapable of being believed. This applies not just in defense, but in accusation. Advertisement. If you are poor, emotional, or diagnosed with something, the system often starts treating you as unreliable. Your word is taken less seriously. Your credibility is marked down before you've opened your mouth. Advertisement. In Indiana vs. Edwards 554 U.S. 164, 2008, the court ruled that a person could be competent to stand trial but not to represent themselves. In plain terms, you can be punished, but you can't speak for yourself. Advertisement. The agency, the forgotten principle. What ties these threads together? One word: agency. Agency is the power to act, to initiate, to accuse, to demand. It's not something given, it's something exercised. And the justice system, as it currently functions, too often denies the poor this fundamental capacity. Advertisement. When you assume you're the defendant, you surrender your agency. When you confuse confusion with helplessness, or frustration with guilt, you abandon the idea that you are the one who should be making demands, not answering them. Advertisement. The legal system respects those who assert. The prosecutor asserts. The accuser asserts. Agency, properly understood, means stepping into that role when you've been wronged, not sitting quietly in the role of a suspect who never got charged. Advertisement. If there's a principle to teach above all others, it's this: agency belongs to everyone, or it belongs to no one. And it must begin with recognizing when you are the one who should be calling the shots. Advertisement. V. Comparative examples and reasonable reform. Unlike the U.S., some countries have structures that help the poor function as citizens, not permanent defendants. In Germany, prosecutors are required to investigate both for and against the accused, giving them an incentive to get things right. Plea bargaining is rare, and oversight is strict. Advertisement. The Netherlands and Scandinavian nations fund victim services that are part of the justice system, not charity sideshows. In Canada, legal aid isn't just for defense. It can also support bringing legitimate complaints against bad actors. Advertisement. None of this is utopia. But these systems make fewer basic mistakes about who needs what kind of help. 7. A modest blueprint. We don't need to blow up the system to improve it. We need legal aid centers that know when to point someone to a prosecutor instead of a defender. Training for first responders and legal workers to recognize that some poor people are complainants, not suspects. Community education programs that teach the basics. If you've been wronged, you may have the right to press charges. Clear avenues for victims, regardless of income, to ask for formal prosecution, not just civil claims or apologies. 8. Conclusion. So who ya gonna call? This isn't ideology. It's clarity. If someone takes your property, hits you, defrauds you, you don't start planning your defense. You start preparing your accusation. The legal system is complex, yes, but this principle is not. Advertisement. The poor must learn what has too often been withheld from them. They are not always on trial. Sometimes, they are the ones wronged. And when they are, they don't need an apology or a settlement. They need to reclaim their agency. Advertisement. So, thinking of getting a lawyer. What are you accused of? Nothing. Then why do you want a lawyer? On account of that dirty dog who robbed you. Why are you talking to a defense attorney? They will ask you for your evidence in a way that makes it clear they would happily defend them. I suspect you need to start thinking about what kind of evidence a prosecutor wants if they are going to be able to help you. Advertisement. Because if you're making an accusation, you don't call a defense lawyer. And you sure don't call the Ghostbusters. You call someone who can make your accusation mean something. Advertisement.